Welcome, curious minds, to another deep dive. Today, we're unpacking a really fundamental piece of South African legislation. It impacts millions of workers and employers. We're talking about the Compensation for Occupational Injuries and Diseases Act of 1993, COIDA. We've got quite a stack of sources here, but it's full of the act itself, naturally, its various amendments over the years, and critically, some new laws that have been passed but aren't actually in effect yet. We call those uncommenced amendments. Our mission today: to help you navigate this act, we want to understand its core purpose, its key provisions, and importantly, its real-world significance. So whether you're maybe an aspiring legal professional, an employer trying to get things right, or just keen to understand your workplace rights, well, you're definitely in the right place.
That's exactly right. And this isn't just about, dry legal text. It's really about understanding the safety net it provides for employees and also the structured system it creates for employers. We'll look at what's currently in force, but also explore those fascinating uncommenced amendments that are really poised to reshape the landscape quite significantly.
Okay, let's dive in then. At its core, what challenge, what problem was the Compensation for Occupational Injuries and Diseases Act back in 1993, Act 130, actually designed to solve in the South African workplace?
Well, historically, you see, if an employee got injured at work, their main option was often to sue their employer, go to civil court, prove negligence, and that, as you can imagine, was often a long, expensive, and pretty uncertain process. COIDA basically stepped in to replace that system. Its stated purpose is to provide for compensation for disablement caused by occupational injuries or diseases sustained or contracted by employees in the course of their employment, or for death resulting from such injuries or diseases. The absolute key thing here is that it established a no-fault system.
A no-fault system. Okay, that sounds like a really fundamental shift. What does that actually mean for an employee on the ground?
It means that if you, as an employee, are injured or perhaps fall ill because of your work, you generally receive support without having to prove your employer was negligent or at fault. This really prioritizes certainty and speed for the injured worker. It moves away from a system focused on blame towards one focused on providing, swift, guaranteed relief. It's about ensuring that safety net, regardless of who was technically at fault in most situations.
Okay, that makes sense. So who exactly is covered by this safety net? And what counts as an accident or an occupational disease under COIDA? These definitions must be key.
Great questions. Absolutely crucial, because these definitions are not only vital, they're also definitely evolving. Currently, the term employee covers a really wide spectrum. Think casual workers hired for a business, directors who have a service contract, even people supplied by what used to be called labor brokers. However, there are significant exclusions. Military personnel, certain police members, independent contractors are not covered. And a historically very significant exclusion: domestic employees in private households.
Wait, hold on. Domestic employees are excluded. That seems like a huge group of workers, often in quite vulnerable positions, left out of this protection.
Indeed, it has been a major gap. But this is exactly where the upcoming amendments bring a massive societal shift. The uncommenced amendments from Act 10 of 2022 are specifically set to remove this exclusion. They will extend COIDA's vital protection to domestic employees. It reflects a growing recognition, really, of their rights and their contributions. And also, just a terminology update, labor brokers are being updated to temporary employment services to align with more modern language.
Right, keeping the language current. Okay, so what about the term accident? How is that defined?
As for accident, the current definition is quite broad. An accident arising out of and in the course of an employee's employment and resulting in a personal injury, illness, or the death of the employee. Pretty comprehensive. The upcoming amendments, though, will expand this slightly to explicitly include occupational disease as a result of an accident. It just makes the language a bit tighter, a bit more explicit.
An occupational disease itself. Is there like a specific list, or can any illness potentially count if it's work-related?
It primarily refers to diseases that are listed in Schedule 3 of the Act, provided they arise out of and in the course of employment. What's fascinating here, legally speaking, is the presumption. If an employee was doing work mentioned in Schedule 3 for a specific disease listed there, it's presumed that disease arose from their employment unless the contrary is proven. That's a really powerful presumption for workers. It eases their burden of proof significantly. And in what I think is a very progressive move, post-traumatic stress disorder, PTSD, is specifically being added to the definition of occupational disease with those 2022 amendments.
Wow, PTSD included. So is it clearly moving beyond just the visible physical injuries to acknowledge the unseen toll work can take? That really broadens the scope, doesn't it?
It really does. It reflects a much more comprehensive understanding of workplace harm, including those significant psychological impacts.
Okay, and what about who qualifies as a dependent? If tragically an employee dies because of their work, who receives the support then?
That's another area seeing quite significant updates to reflect modern families. Currently, it includes spouses under civil or indigenous law, partners living as husband and wife, and children under 18. That includes stepchildren, adopted children, posthumous children, even children born out of wedlock. It also covers older children, parents, or siblings if they were financially dependent on the employee. The upcoming amendments, though, expand this even further. They'll recognize life partners explicitly, and they extend coverage for children receiving tertiary education up to age 25.
That seems much more inclusive, reflecting how families actually look today and acknowledging the financial dependency can continue longer, especially with education.
Precisely. It's aligning the law with societal reality.
And when we talk about compensation, is it just a straight cash payout, or does it cover other things too?
It's definitely more than just a payout. Currently, it explicitly includes medical aid or the cost of that medical aid. But under the upcoming amendments, it's going to explicitly spell out that it includes constant attendance care allowance and funeral costs. That's a very practical clarification, ensuring these crucial needs are covered during what's obviously a very difficult time for families.
Okay, so we have these foundational definitions. We know who might be covered and for what. How is this whole system actually administered? Who are the key players making it work day to day?
Well, the Act sets out a pretty clear structure. Overall administration technically falls under the Director General of the Department of Labor. But in practice, many functions are delegated down to the Compensation Commissioner. The commissioner, and that's a term you'll see largely replacing Director General for many administrative roles in the upcoming amendments, is really the central figure. They're the ones inquiring into accidents and diseases, adjudicating the claims, issuing the payment orders, deciding on those crucial questions like, is this person an employee? Or is this entity the employer? They also manage the money, the compensation fund, and the reserve fund. It seems like a move towards greater administrative modernization, sort of streamlining roles.
Right, so the commissioner handles the operational side. But there's a board involved too, isn't there? It's not just one person calling all the shots. How does that oversight work?
Exactly. There's the Compensation Board. Its main role is advisory. It advises the minister on policy matters. Things like the nature and extent of benefits, how pensions should be adjusted, who should be appointed as assessors, and even potential amendments to the Act itself. It's designed, crucially, to bring together different voices, representatives from employees, from employers, from medical bodies. That ensures diverse perspectives are considered when shaping how the system operates. Future changes are set to alter its composition slightly and introduce a formal board charter, which should further professionalize its role. So yeah, Commissioner handles the day-to-day, the board provides that strategic oversight and advice.
That makes sense. A good balance. Now, the big question, where does all the money actually come from? To pay out compensation, run the administration, keep this whole system going?
It's primarily funded by the Compensation Fund, and that fund is financed by assessments paid by employers. Simple as that, really. There's also a separate reserve fund, which is designed to handle unexpected surges in claims or unforeseen demands, and also to help stabilize those assessment tariffs over time so they don't fluctuate wildly year to year. What's quite important to note is that both these funds are exempt from income tax. This ensures all the resources go back into the system, ultimately to benefit employees. And the money isn't just for compensation payouts. It covers medical aid, the operational costs of the commissioner's office, and significantly rehabilitation services, which, as we'll see, is a major growing focus.
Okay, speaking of employers paying assessments, what are their other key obligations under COIDA? What do they absolutely need to do to comply?
Right. Employers have several critical duties. First, they absolutely must register. They need to register with the commissioner, or the compensation fund as it will be termed, and provide all their business particulars. Second, they have to maintain records. Records of employee earnings, other prescribed details, for at least 4 years currently, though that's going up to 5 years under the upcoming amendments. And importantly, health and safety reps and trade union reps have the right to inspect these records. That ensures transparency.
Okay, registration and records. What else?
Third, they must annually furnish returns of earnings, usually by March 31st. This is what the assessments are based on. And under-declaring can lead to hefty fines. Fourth, based on those returns, they pay the assessments. It's calculated as a percentage of their employees' annual earnings. This is what actually funds the compensation fund. There are minimum assessment levels, and the minister can also set maximum earnings limits for the calculation. Just to give you an idea, the current maximum earnings level is over R600,000 per employee per year. The minimum assessment for most employers is around R1,600, and for domestic employers, it's currently set lower, about R560. Though it's worth noting, some employers are exempt from paying directly into the fund, like national and provincial government departments or large employers who have specific insurance arrangements through mutual associations.
So there's some variation, but generally employers contribute. What about those with really good safety records? Do they get any kind of break on these assessments?
Absolutely. That's the fifth key point: variation of tariff. Employers who demonstrate good safety records, who have lower accident rates, might get lower assessment rates or even rebates back from the fund. And interestingly, under the upcoming changes, actively participating in rehabilitation programs for injured workers will also qualify employers for rebates. That's a clear incentive for proactive safety and recovery measures. Conversely, of course, poor safety records can lead to higher tariffs. The system is definitely designed to financially encourage safer workplaces.
Makes sense. So if an employer doesn't comply, fails to register, doesn't report accidents, doesn't pay up, are there serious penalties?
Oh, absolutely. The consequences can be severe. Failing to register or report accidents or pay assessments can lead to significant fines. Under the upcoming amendments, for instance, failing to report an accident can result in a penalty equal to the full amount of compensation payable for that accident, plus interest calculated from the date the accident occurred. That's a huge deterrent. And the Act is also very clear. Employers are strictly prohibited from deducting any amount from an employee's earnings to try and offset their own COIDA liabilities. That's a specific offense, and the commissioner can order reimbursement if that happens.
Okay, let's shift focus a bit to the employee side. If an employee is injured or gets sick from their work, what's their fundamental right to compensation, and how does that whole process actually kick off?
Right. So an employee who suffers disablement, temporary or permanent, or sadly, death due to an occupational accident or disease is entitled to benefits under the Act. One small caveat: no periodical payments are usually made for disablement that lasts 3 days or less. The system focuses on more significant impacts. Now, here's where it gets really interesting, especially if you're tracking legal trends and worker protection. Currently, there's a clause: if an accident is due to the employee's own serious and willful misconduct, compensation isn't payable. The only exception currently is if that misconduct results in serious disablement or death, leaving a family that was wholly financially dependent.
That sounds like a potentially significant loophole, doesn't it? Penalizing an employee for maybe a lapse in judgment, even within a no-fault system. Is that changing?
This is a major shift coming, a really significant boost for employee protection. The upcoming amendments completely remove this exclusion based on serious and willful misconduct. It means compensation will be payable even if the employee's own serious misconduct contributed to the accident. It strongly reinforces the no-fault principle of the system.
Wow, okay, that is a big change. What about accidents that happen outside the normal workplace? Say during travel to or from work, or if someone's working abroad temporarily. How far does COIDA's protection actually extend?
The Act does provide some coverage beyond the typical factory floor or office. For instance, it can cover accidents happening outside South Africa if the employer's business is primarily based in South Africa and the employee is just temporarily abroad, usually up to 12 months, though longer periods can be agreed upon. It also explicitly covers employees working on the continental shelf, think offshore oil rigs, for example. And another crucial upcoming change broadens this significantly. The conveyance of an employee to or from work, if it's done by or on behalf of the employer in furtherance of the business, will now be deemed to be in the course of employment.
So that's potentially much broader than just, say, being in an official company bus.
Right.
It covers more commuting scenarios.
Exactly. It recognizes the realities of how people get to work, especially when the employer facilitates it in some way connected to the business. It significantly expands the scope of coverage there.
Okay, so let's imagine our hypothetical worker, let's call her Sarah, gets injured. How does the claim process actually begin for her? What are the first steps?
It really starts with giving notice. Sarah, or someone on her behalf, should give written or verbal notice of the accident to her employer as soon as reasonably possible. The employer then has a legal duty within 7 days to report that accident to the commissioner using the prescribed forms. What's important for employees like Sarah to know is that failing to give that initial notice doesn't automatically bar her claim, especially if the employer clearly knew about the accident anyway, or if the compensation fund isn't seriously prejudiced by a slight delay.
And medical examinations, I assume they're a crucial part of verifying the injury and the claim.
Absolutely essential. Employees claiming compensation must submit to medical examinations by a medical practitioner designated by the commissioner or the employer. Generally, the party who requests the examination pays for it. Now, under the upcoming amendments, there are two key additions here that benefit employees. First, employees might also be required to undergo examinations specifically for rehabilitation purposes. This links directly into that new focus on holistic recovery we mentioned. And second, if an employee like Sarah gets her own medical report at her own cost, and the commissioner finds it acceptable and useful for the claim, those medical expenses must be reimbursed to her. That's a practical win, removing a potential financial barrier.
That's really helpful. Is there a strict deadline for actually lodging the claim itself? Or can it be done years later?
Currently, the rule is that claims must be lodged within 12 months of the date of the accident or the date of death. However, this is another area with a really major upcoming amendment that provides much more leeway. Under the new provisions, the right to benefits will only lapse if the accident is not brought to the attention of the commissioner or the employer within 3 years from the date of the accident.
3 years. That's a significant extension from 12 months. Gives people much more time, especially if the effects of an injury aren't immediately obvious.
Exactly. It provides much more flexibility for claimants, recognizing that sometimes the link between work and an injury or disease only becomes clear later on.
Okay, let's get to the bottom line then. Once a claim is accepted, how is the actual compensation calculated? What do employees or their families typically receive?
Right. The compensation varies quite a bit, depending on the nature and the degree of disablement. For temporary total disablement, meaning the employee can't work at all but is expected to recover, it's typically 75% of their monthly earnings at the time of the accident. This is paid periodically, like a salary, for up to 24 months. An interesting point here is that the employer is initially liable to pay this amount for the first 3 months of disablement. They then get reimbursed by the compensation fund. And if an employer fails to pay that initial amount, they can be penalized quite heavily, up to double the full amount of 3 months compensation plus interest. It ensures employees get that immediate support.
Okay, 75% of earnings for temporary disablement paid by the employer first. What about permanent disablement, when the injury has lasting effects?
That's more complex. Schedule 2 of the Act lists specific injuries, like losing a limb or sight in an eye, and assigns a fixed percentage of permanent disablement to each. For injuries not listed in that schedule, the commissioner, often relying on medical assessments, determines the percentage of disablement based on the injury's impact on the person's ability to work. An important upcoming update here is that the commissioner will have the power to review pension claims later on, to reassess the degree of permanent disablement. This acknowledges that an employee's condition might worsen or even improve over time. Also, the amendments clarify that monthly pensions for permanent disablement will commence from the date a medical practitioner certifies that the employee has reached maximum medical improvement, or maximum medical intervention, basically, the point where further treatment isn't expected to significantly improve the condition.
So for permanent disablement, is it always a monthly pension payment, or can people get lump sums?
It can be both, depending on the circumstances. If the calculated monthly pension is relatively small, the commissioner has the discretion to pay it out as a single lump sum instead. Or, even for larger pensions, the commissioner might commute a portion of it into a lump sum. However, pensions specifically awarded to dependent children are generally not paid out as lump sums, ensuring that ongoing financial support during their formative years.
Okay, that makes sense for protecting children's long-term interests.
Yeah.
What happens if the worst occurs and an employee dies as a result of the work injury or disease? How does compensation work for their family, their dependents?
In that tragic situation, compensation is paid to the dependents we discussed earlier, the spouse, life partner, children, other financially dependent relatives. This typically involves a combination of benefits. There might be an initial lump sum payment. For example, a widow or widower with no dependent children currently gets a lump sum. The maximum is around $74,000. And then, crucially, there's usually a monthly pension as well. For that same widower, the pension is calculated as 40% of the pension the deceased employee would have received if they had been 100% permanently disabled. There's a maximum monthly amount for this, currently around $14,900. Dependent children also receive pensions. These typically continue until they turn 18, or potentially longer if they're still completing secondary or tertiary education, or indefinitely if they have a physical or mental disability that prevents them from earning a living, assuming the employee would likely have continued supporting them. And on top of that, reasonable funeral costs are also covered by the fund, up to a specified maximum amount, which is currently just over our $20,000 per valid claim.
Right. Now, what if the accident wasn't just an accident, but was clearly caused by the employer's negligence? Maybe unsafe equipment, poor procedures. Can the employee get more compensation beyond the standard COIDA benefits in that case?
Yes, there is a specific provision for that. An employee or their dependents in case of death can apply for increased compensation if they can prove the accident or occupational disease was directly due to the negligence of the employer or someone in a management position acting on the employer's behalf. There's a time limit for this application. It must be lodged within 24 months of the accident or disease diagnosis, though the commissioner can grant an extension of up to 12 months if there are good reasons for the delay. If this increased compensation is awarded, the crucial point is that the total amount received, meaning the standard COIDA compensation, plus this negligence-based increase, cannot exceed the actual financial loss suffered by the applicant due to the injury or death. It's not punitive damages, it's about covering the actual loss.
Okay, that's an important avenue for employees in negligence cases. How are an employee's earnings actually calculated when determining all these compensation amounts, the 75%, the pensions? What counts as earnings?
That's defined quite specifically. The commissioner calculates the earnings to determine the employee's monthly remuneration at the time of the accident. This calculation includes the basic wage or salary, obviously. It also includes the value of any food or accommodation provided by the employer as part of the package, and any regular overtime pay or other regular payments that form part of their normal remuneration. However, it explicitly excludes things like intermittent or casual overtime, payments for non-recurrent services, special expenses incurred for work like travel allowances, or any ex gratia payments, discretionary bonuses not part of the contract. There are also specific guidelines in the Act for how to calculate earnings fairly for employees who maybe only worked for a very short time before the accident or those who worked for multiple employers concurrently. And as we mentioned, there's a maximum earnings threshold used for calculating the employer's assessments, and this often influences the maximum benefit payouts too. As of March 2025, for instance, that maximum threshold is set at around R$633,000 per employee per year.
That clarifies what goes into the calculation. Now, there's a really fundamental legal principle tied up in COIDA, isn't there? Something about giving up the right to sue.
Yes, absolutely crucial, especially for anyone studying law, but also important for everyone to understand. COIDA makes compensation payments non-alienable. That means the money can't be signed away, pledged as security for a debt, attached by creditors, or set off against other debts the employee might have. It's protected. And critically, Section 35 of the Act explicitly states that no action shall lie by an employee or any dependent for the recovery of damages against the employer in a civil court for an occupational injury or disease that results in disablement or death. The only recourse against the employer for such an injury or disease is through the mechanisms provided under this Act, like the increased compensation for negligence we just discussed. This is often called the substitution of remedies or the statutory bargain. Essentially, employees give up their common law right to sue their employer for damages in exchange for the guarantee of quicker, no-fault compensation under COIDA, even if that compensation might sometimes be less than what a court might award.
So that's the trade-off, basically. Guaranteed, faster support under COIDA versus the potential for a bigger payout, but also the risk, cost, and delay of a civil lawsuit.
Exactly. That's the fundamental bargain at the heart of the Act.
Okay. This Act, passed way back in 1993, has clearly been tweaked and amended many times over the decades. And as we've touched on throughout, more really big changes are coming with these uncommenced amendments. What are some of the most impactful future changes that are truly poised to reshape the COIDA landscape?
You're right. The uncommenced amendments mainly stemming from the Compensation for Occupational Injuries and Diseases Amendment Act 10 of 2022, and also some interactions with the new National Health Insurance Act 20 of 2023 introduced some very significant shifts. They're really aiming to modernize the act and expand its scope considerably. Perhaps one of the biggest, most holistic changes is the introduction of a completely new chapter, Chapter 8 Une, on rehabilitation, reintegration, and return to work. This represents a profound philosophical shift for COIDA. It's not just about paying out money anymore. It mandates the compensation fund, or those individually liable employers or licensees, to provide comprehensive rehabilitation facilities, services, and benefits. This includes clinical rehab, vocational rehab to help people find suitable work, and social rehabilitation. The whole aim is to proactively help employees return to work if possible, reduce the extent of their disability, and help them achieve maximum independence in their lives.
So moving from just compensation to actual restoration and reintegration, that sounds like a massive and very positive shift in philosophy.
It really is. It transforms COIDA from being largely a reactive payout system into one that actively supports holistic recovery.
What else is coming down the line that will significantly impact how injured or ill workers are cared for under this system?
Well, then we have potentially major medical aid changes on the horizon. The 2022 Amendment Act does initially tweak some medical aid provisions, things like making it easier to reopen claims for further necessary medical costs and requiring third-party medical service providers to register directly with the compensation fund. However, the potentially bigger change comes from the National Health Insurance Act, NHI Act 20 of 2023. That act explicitly states that the entire chapter dealing with medical aid in COIDA, that's Chapter 8, will be repealed once the relevant sections of the NHI Act commence. This signals a fundamental future shift. It suggests that the costs of medical treatment for occupational injuries and diseases might eventually be managed under the broader umbrella of the National Health Insurance System, rather than solely through the COIDA fund. The exact implications are still unfolding, but it's a critical point to watch.
Okay, so the way medical care is funded and delivered could change quite dramatically depending on how NHI rolls out. What about other significant changes?
Another really crucial one, found in an amendment to Section 36, concerns the Road Accident Fund, RAF, exclusion. This amendment explicitly states that the RAF will not be considered a third party from which the compensation fund, or a licensee employer, can recover damages or compensation paid out under COIDA. This has major implications for those unfortunate cases where a work-related injury happens because of a motor vehicle accident. It essentially prevents a double dip or recovery between these two major state compensation funds, clarifying where the liability ultimately rests in such overlapping scenarios.
That clarifies the interaction between those two big funds. And to make sure everyone actually follows all these rules, new and old, what's changing on the enforcement side? Is the act getting more teeth?
It certainly seems so. There's an entirely new chapter being added, Chapter XA, on inspection, compliance, and enforcement. This introduces a dedicated, formal framework for inspectors appointed under the Act. Their job will be to promote, monitor, and enforce compliance with COIDA across the board. This includes giving them specific powers to enter workplaces, though usually requiring consent or a court order, powers to question individuals, powers to inspect and copy relevant documents, and crucially, the power to issue legally binding compliance orders to employers who aren't meeting their obligations. It definitely looks set to significantly beef up the regulatory and enforcement capacity associated with the Act.
More robust enforcement. And you mentioned some general tidying up, too.
Yes, finally, there are numerous streamlined terminology and administrative changes scattered throughout. Many are simply updating outdated terms like changing airmen to air personnel, or replacing references to the old Supreme Court with the appropriate labor court or high court, depending on the context. And as we noted earlier, the administrative functions previously assigned to the Director General are largely being centralized under the Commissioner. This should clarify responsibilities and hopefully streamline the day-to-day administration of the system.
Okay, pulling all of this together. If someone listening is trying to navigate the South African legal landscape, perhaps as a law student, or maybe just trying to understand their basic rights and responsibilities in the workplace as an employee or employer, what does COIDA, with all these changes, really mean for them?
I'd say COIDA is absolutely fundamental. It's a cornerstone of South African labor law. Its no-fault compensation system is the defining feature. For an employee, it means you don't usually have the burden of proving your employer was negligent just to get essential benefits like medical care and wage replacement after a work injury. This generally provides swifter, more certain relief compared to the potential gamble of a civil lawsuit. For law students, understanding that substitution of remedies, we talked about Section 35, is absolutely crucial. It fundamentally alters how workplace injury claims are handled compared to other types of personal injury claims under common law. And for the general public, for employers and employees alike, it means knowing that there's a clear, established, albeit complex, process specifically designed to provide support and manage recovery when work results in injury or disease.
It really sounds like it tries to strike a balance, doesn't it? Protecting employees financially and medically, while also shielding employers from constant, potentially crippling negligence lawsuits. It aims for a more predictable and efficient system for everyone involved.
Precisely. By providing this statutory framework, it aims to foster greater industrial peace and economic stability. Employers contribute to the fund, employees get defined benefits, and these ongoing amendments, especially the significant uncommenced ones we've discussed, clearly show that it's not a static piece of legislation. It's a living document, constantly adapting, sometimes slowly, sometimes quite radically, to reflect societal changes, evolving medical understanding, and new concepts of workplace well-being. Think about the inclusion of PTSD, the much broader definitions of dependent, and especially that major new focus on holistic rehabilitation. These all demonstrate a more progressive, more inclusive approach to worker protection emerging over time.
This deep dive into COIDA really has highlighted just how legislation like this constantly evolves, trying to meet the needs of a changing society and a changing world of work. From the initial concept of basic compensation through all the administrative tweaks, to this new, really significant emphasis on rehabilitation and the expanded definitions of who's covered, it's clear this act remains a dynamic and incredibly important force in the South African workplace.
Indeed. And understanding these intricacies, both the current rules and what's coming, helps us all appreciate the complex legal framework that supports millions of workers, providing at least a measure of security during what can be incredibly challenging times after a workplace injury or illness.
So as we look to the future with these major amendments waiting in the wings, but also thinking even beyond them, what further roles do you think legislation like COIDA might need to play, or how might it need to adapt further to really shape the evolving nature of work itself? I mean, especially thinking about the huge rise of remote work, the gig economy, platform workers. How does a system designed largely around traditional employment relationships keep pace with those fundamentally new realities? That's certainly something to mull over. Thank you for joining us on this deep dive.